Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Welcome to this month's Third Thursday webinar presented by Synergy Settlement Services. My name is Jason Lazarus, Chief Executive Officer of Synergy, and today's presentation is going to focus on Medicare Set-Asides. We're going to discuss having a process within your firm to address MSP-related issues, talk about Medicare set-aside allocations, funding of set-asides, and post-settlement administration of a set-aside. So really all the nuts and bolts you need to know about when dealing with Medicare set-asides. It's really important to understand the differences between different government benefit programs when advising clients about what they need to do at settlement. So there's two big categories that you should be aware of. Those are needs-based income and asset sensitive benefits, which we're not going to talk about today. Those are SSI and Medicaid, and then also the entitlements, which are SSDI and Medicare. And today we're going to talk all about Medicare. But knowing the difference is important. Many clients confuse these benefits because Social Security provides both SSDI and SSI, and people get Medicaid and Medicare confused. So you really want to make sure that you identify exactly what that client is receiving, because what you need to do depends on what type of benefits they currently get and what they want to preserve at settlement. So before diving into all of the Medicare secondary payer details, I wanted to start at the 30,000-foot level, which is what are the obligations under the Medicare Secondary Payer Act? So there are really two distinct obligations, one from the date of settlement backwards, which are liens, Medicare conditional payments, Medicare Advantage liens. That's very clear, crystal clear, in fact, for most. What's a bit more murky are Medicare set-asides, which are from the date of the settlement forward or futures. And also keeping in mind that Section 111 reporting is an important piece of all of this, because when a settlement occurs with a Medicare beneficiary, defendants now must report settlements to Medicare, and it is a data dump. A lot of information gets transmitted to Medicare, including ICD codes and dates of accident and a lot of other information. And that's what triggers these issues now coming to the forefront, is reporting under the Section 111 mandatory insurer reporting. We'll talk a little bit more about that and the implications later on. So let's do a little bit of a deeper dive into the Medicare Secondary Payer Act and liability Medicare set-asides. So the Medicare Secondary Payer Act is important because Medicare can deny injury-related care based on the Medicare Secondary Payer Act. And what triggers that is that mandatory insurer reporting I mentioned just a moment ago, because when a defendant insurer reports to Medicare the ICD codes, that goes into the Medicare beneficiary's common working file, which could result in a denial of future care. And if a client was denied care by Medicare, there are 4 levels of internal appeals before you ever get to set foot inside of a federal district court. And there's a ton of cases out there that all of those remedies must be exhausted before you get the opportunity to address these issues in federal court. So you could have a client who went without care for over a year if Medicare decided to deny care before you get to raise the issue in a federal district court. And really it's a malpractice risk for trial attorneys, because if the client doesn't understand this risk and becomes the unfortunate Medicare beneficiary who gets a denial of care, then they can claim legal malpractice against you for failing to advise. And a lot of the presentation is going to be focused on this advisement obligation because it really is the most important message as a takeaway from today's presentation is you've got to advise the clients about these issues and risks. Since we're talking about the Medicare Secondary Payer Act and futures, I wanted to point out that as we currently sit here today, there are currently no regulations that mandate a Medicare set-aside. But there is a move on the part of Medicare to codify the responsibility of setting up a Medicare set-aside. And what you see on the screen is currently what's before the Office of Information and Regulatory Affairs, OMB, is a potential proposed rulemaking for these issues. And you see what's highlighted there, the rule would be created that would make sure that Medicare beneficiaries satisfy Medicare's interest with respect to future medical items under this proposed rule. So even though we don't have current law on the subject, it is coming. It's just a question of when. Although this has been in process for quite some time, you still need to make sure that clients understand that there are potential rules coming down the pike, and if they fail to do something, they could wind up being denied future medical coverage for their injury-related care by Medicare. So key points, as I just stated, there's currently no regulations or statute related to Medicare set-aside. So in my opinion, it's very similar to a situation with a client who's on Medicaid, needs-based government benefits. You want to advise them, hey, you could potentially lose your benefits if you don't set up a special needs trust. Really, MSAs are no different from that as we sit here today. And remember, these issues only are applicable if you're dealing with a settlement with a current Medicare beneficiary, so that's someone that's disabled, 65 or older, someone with end-stage renal disease, ALS, or a disabled adult child. Arguably, if they have a reasonable expectation of becoming a Medicare beneficiary with 30 months, they fall within this category as well, although that is a little more remote because those settlements are not reported to Medicare because they're not currently eligible. But if someone's become eligible for SSDI, within 24 months, they will get Medicare coverage. The 30 months comes from the 6-month elimination period before you get your first SSDI check, so 30 months in total. But also remember that even though I'm going to talk a little bit about Medicare set-asides, that's not the only solution to considering Medicare's interest. What you're trying to do is make sure that the client doesn't shift the burden to Medicare with the future medicals as it relates to the settlement. But for example, they could elect into Medicare Advantage plans. Arguably, those do not have MSA issues. They could elect private insurance. They become self-pay. You could set up a medical management trust for future medicals, or set up a structured settlement. So there's a lot of different ways to deal with these issues. But if you've got a client who's Medicare eligible, needs future injury-related treatment, and future medicals are funded by the settlement, that's when you want to consider whether an MSA should be established or do something alternatively. And of course, Medicare's preferred method to protect the trust fund is an MSA. So if you take nothing else away from this portion of the presentation, it's that you need a process within your firm to identify cases with Medicare beneficiaries and make sure that if the settlement funds future medicals, the client is educated on the risks of failing to consider Medicare's interest, and make sure that the client gets to select the appropriate solution for their risk tolerance. And the acronym CAD is a quick way to remember making sure that you're consulting with experts like Synergy or some other third party that understands the intricacies of the Medicare Secondary Payer Act, making sure the client is advised about these issues, and then most importantly, documenting your file. Because documenting your file shows that you did everything that you possibly could to protect that client, which is really your risk, which is malpractice risk. Medicare is not going to come after your law firm if a client fails to set up a set-aside. They might just simply deny that client future medical care under Medicare, and in which case, if you've not advised the client about that, then they can come back potentially and make a legal malpractice claim for failing to advise them about a legal issue, which this certainly is. So now let's talk a little bit about what is a Medicare set-aside. The easiest way to think about a set-aside is that it's really a deductible that a client is self-pay for Medicare covered expenses until they exhaust the portion of the settlement that's allocated to future medical that's covered by Medicare. So it's taking a portion of the settlement, setting it aside for injury-related medical expenses normally covered by Medicare. And the way it's calculated is, according to CMS's guidelines, you take the injury-related medical expenses normally covered by Medicare, plus prescription drug expenses under Part D covered by Medicare, multiply that by the client's remaining life expectancy, which can be reduced using rated ages, which I'll talk about momentarily. And that's how you come up with what's called a Medicare set-aside allocation, allocating a certain amount of money for future Medicare covered expenses that is set aside and used for those future Medicare covered expenses. So we've covered the obligations under the MSP Act, just talked about what is a Medicare set-aside. So next, let's turn to how do you fund a Medicare set-aside? So remember, the MSA is calculated by doing the calculation I mentioned earlier, which is your allocation. And then once you've got that amount figured out, then the question becomes, do you put it in as a lump sum, which is option 1, or fund it over time with an annuity, which is option number 2. So if you do a lump sum, that means that the entire amount that is calculated for the client's future Medicare covered expenses over lifetime must be put in a single lump sum into some type of segregated account. Usually this is not preferable because it's more expensive to do it that way, and I'll explain that a little bit more in a moment. And more money is being spent on Medicare covered services first because of total exhaustion versus temporary exhaustion, which I'll talk about in a little more detail as well in a moment. So the alternative is doing a structured settlement, which allows you to put seed money into the Medicare set-aside account and have annuity payments flowing in over time on an annualized basis. The seed is 2 years worth of treatment and medications plus the first 2 surgeries, and then the annual payments that go into the Medicare set-aside via the annuity are calculated by the remainder of the MSA after seed divided by normal life expectancy minus 1. So that's how you calculate it if annuity funding parameters are going to be used. And when an MSA allocation is done, a company that does that, like our company, will give the MSA annuity funding parameters as part of the report. In most cases, a structured settlement is the best way to fund a Medicare set-aside. And the reason for that is because it's a lower cost, which I mentioned previously. Typically, it's anywhere from 20 to 40% less than putting the entire lump sum in because of the time value of money and because of rated ages. All of those things reduces the MSA, particularly because Medicare accepts rated ages, which is a reduced life expectancy provided by a life insurance company, as evidence of what life expectancy should be used for the MSA. And as I mentioned, this concept of temporary exhaustion, what that means is that every year the MSA can be exhausted. So when you put the seed in, if the next year there's an annuity payment and all of that is spent in 1 year, then Medicare picks up for the remainder of that year until the next annuity payment flows into the MSA. Compare that with a lump sum funded MSA where the entire amount that's in the MSA has to be spent before Medicare picks up $1. So as you can see from that, that's a huge difference. Also, structured settlements typically reduce the cost of funding professional administration for an MSA, and I'll talk a little bit about that later on. And then there's the tax benefit you get with structured settlements, which gives a greater net rate of return, and also creditor and judgment protection that you get with structured settlements, which you don't get with simply just putting the money into an MSA. There are three main types of annuity funding vehicles using a structured settlement for a Medicare set-aside. The first one, which is typically proposed by carriers and work comp settlements, or would be the preferred method of an insurer because it's the cheapest method, is temporary life, which means the payments are only made as long as that person is alive for the maximum of the life expectancy for the MSA. But if that person dies prematurely, then that means the family gets nothing or the heirs get nothing, and potentially could create an E&O claim for a personal injury attorney if they don't advise the client about those risks. So typically temp life is really not a consideration if someone who is advising the plaintiff understands these different ways to fund it. Second option is either life with a premium guarantee, which means a life annuity with a guarantee long enough that the cost is returned over the guarantee period, or a period certain annuity that's set up to pay only for the life expectancy used in the set-aside. This is the most efficient way to fund an MSA while still protecting a surviving family. The third option is a life with some sort of longer guarantee. I put 30 years, could be 35 years, could be 40. It's more expensive and could potentially overfund the MSA, but provides the most for the survivors at death. I've talked a little bit about rated ages, and I wanted to emphasize the point of really how much utilizing a structured settlement with a rated age will reduce the cost of an MSA amount. So what you see here is a real-world example of this in a workers' comp case where the MSA amount was $227,000. So if you funded it with lump sum, that's how much would have to go into the MSA. If you fund it with an annuity, and these were the actual calculations, the annuity cost was $109,105 plus the seed amount of $29,208, so $138,000 total cost to fund the MSA instead of $227,000. Now this was using the cheapest method, which is a temporary life annuity, so it would increase the cost somewhat, but there still is a pretty significant cost savings to funding an MSA using a structured settlement with a rated age. So if you're setting up a structured settlement to fund an MSA, the question is, how do you decide which method to use? So what you need is a comprehensive analysis of those three main annuity funding options to make an educated decision. You want to have that comparison of the cost between temp life, premium guarantee period certain, and a 30-year guarantee, and you want to have the benefit of those rated ages because of the reduction of the cost of the annuity and also reduction of the life expectancy used to calculate the MSA. So now that we've talked about funding mechanisms, the last topic, and it's an important one, is how does that Medicare set-aside get administered? So Medicare's guidance is that an MSA should be placed in a segregated interest-bearing account. An injury victim can self-administer that set-aside or have it professionally administered. The set-aside must be spent only on Medicare-covered medical expenses and Medicare-covered prescription drug costs that are specifically related to the underlying injury, and upon exhaustion of the funds and notification to Medicare, Medicare begins paying for those covered services and prescription drugs. The funds that are in the MSA have to be spent pursuant to the fee schedule that's used to calculate the MSA. In liability, that would be usual and customary. In workers' comp, it's workers' comp fee schedule. The client must maintain accurate records and file an annual reporting, and ultimately the MSA funds can't be used for any of the administrative costs for the Medicare set-aside, which doesn't seem fair, but that's the rule. So for injury victims, they've got three primary options when it comes to administration. Self-administration, which is self-management of the funds. The injury victim has to notify Medicare of exhaustion, provide an accounting, and submit a self-attestation about how the funds were used. If a client is using a structured settlement annuity funding vehicle, that's typically not going to be a good case for self-administration, because that means every year they have to try and get Medicare to turn on coverage when they have that temporary exhaustion I talked about. One of the other things that can be done if they want to self-administer is getting a company to provide self-administration support. So helping the injury victim make sure they comply with all the rules and do the right reporting and accounting. For many clients, professional administration is probably going to be the best way to manage a Medicare set-aside, because it removes the burden of trying to make sure that they comply with all the rules and gives them a professional to do it. There are two different ways it can be done. One are custodial agreements, one are Medicare set-aside trusts. So if you do professional administration, then the custodian or trustee handles all management of the money, accounting, and also reporting to Medicare. If someone's incompetent, that really is a situation where you just absolutely have to do professional administration, or if the client's dual eligible, which I'll talk about at the end of the presentation. There are certain cases where you really have to do professional administration, or it's recommended, or you need some self-administration support. So if you have someone who has a designated representative payee, has an appointed guardian, conservator, declared incompetent by a court, is dual eligible, those are all situations where you really must have a professional administrator. Where it's recommended is large MSAs or injury victims that have low educational levels or unsophisticated handling money. And for self-administration support, really any MSA over 25K should have self-administration support, or a case where the injury victim needs assistance. The benefits to the Medicare beneficiary of these administration and support services is making sure they don't lose eligibility due to improper administration, having the availability of an expert to negotiate the cost of future medical services, and making sure that Medicare benefits are not interrupted or delayed for any reason. Dual eligibility is an important topic because a client that's receiving both Medicare and Medicaid benefits have a lot to preserve. And in these situations, actually Medicare is primary and Medicaid is secondary. There are several different programs that Medicaid offers that basically supplements what Medicare pays for. So the program that covers the most are qualified Medicare beneficiary plans through Medicaid, which then Medicaid pays all the Part A and Part B premiums, deductibles, copays, and extra help with Part D costs. There's other programs that provide a little bit less, but if a client is getting both Medicaid and Medicare, that means in most instances they're not going to be out of pocket at all, so you want to make sure that that's protected. The challenge is that when you set up a Medicare set-aside, if you don't put it inside of a special needs trust wrapper, it's an available resource for the Medicaid and SSI eligibility, which are needs-based benefits, which I started out talking about. So when you do have someone dual eligible, then you create a hybrid special needs trust that has Medicare set-aside provisions. Now, the way this is typically done is with two different trusts, because the cost of administration, as I mentioned, cannot be borne by the MSA. So you need a second special needs trust for the non-Medicare funds and to pay for the administrative expenses. And in this scenario, you have a trustee of the special needs trust, but then you also have an MSA administrator. So there's some increased costs, but you can do this with standalone special needs trusts or pooled special needs trusts. Either are an appropriate mechanism to make sure that a dual eligible is completely protected and doesn't lose their needs-based benefits when an MSA is set up. At this point, with all of the detail I've just gone over, you might be thinking to yourself, how do I make sure that I am MSP compliant in dealing with these issues inside of my law firm appropriately? So from a lawyer standpoint, you want to make sure you're protecting your firm from malpractice risks that I've outlined throughout this presentation. The best way to do that is to have a process within your firm and start early compiling public benefit data for disabled clients, making sure that you keep that updated and know what they are receiving when that case resolves. You want to take control of this Medicare secondary payer process from start to finish when it comes to conditional payments, Medicare Advantage liens, or MSAs. You don't want to ever rely on the other side's experts as it relates to MSP compliance issues. They get it wrong all the time. We see it. You'll get release language that doesn't make sense. You'll get problems and delays with Medicare conditional payments. So you got to be proactive. And when the case settles, you have to make sure that the correct data is getting reported to Medicare, both through your processes with the MSPRC and BCRC, and that the defendant is reporting the proper information through mandatory insurer reporting. Briefly, before we conclude today's presentation, I wanted to talk to you a little bit about how Synergy can help your client and your firm with Medicare secondary payer compliance. Really, it's all about protecting your client and your firm. One of the best ways to make sure the client understands all of these issues that I've outlined is hire Synergy to do what we call a MECE, which is a Medicare expert case evaluation. With that, the client will have a customized consultation. You'll get communications that you can provide to the client, a customized acknowledgement that the client doesn't want to do a set-aside if that's what they decide. And also, as part of that, we provide a no MSA evaluation letter if that's appropriate. We can also do a full Medicare set-aside allocation if the client would like to do that. We are able to provide MSA funding solutions, including structured settlements, and then ultimately professional administration through a trust. A new service that we've developed is creating an MSP compliance audit document for a particular case, which is really a way for you to be proactive about making sure that the other side, the defendant, knows that you've addressed the issues. This report would summarize what's been done as it relates to conditional payments and Medicare Advantage liens, as well as future interest, and assist with the proper information that should be reported by the defendant under Section 111 reporting. So this very nicely shows you all the different ways that we can assist, from conditional payment resolution to resolution of Medicare Advantage liens, the Medicare expert case evaluation, Medicare set-aside allocations, Medicare set-aside funding, and ultimately Medicare set-aside administration. So this is my favorite slide. It's a picture of our entire team at our last in-person conference, and that team is dedicated to making sure that injury victims are protected and that your law firm is protected as well. They're driven by our mission, which is improving the lives of the catastrophically injured, and everything we do is focused on making sure that we are doing our absolute best to help you and your client have the outcome that you deserve for that particular personal injury case, because every case is a unique opportunity for us to help that client transition from litigation to life thereafter. And our team is very passionate about that mission. Thanks for tuning in to today's presentation. If you have any questions about the presentation, want to call me and talk to me, email me. All my contact information is here on this slide. If you want to learn more about how Synergy can help you and your law firm, from lien resolution to Medicare compliance to government benefit preservation, settlement planning and consulting, I would encourage you to visit our website or call us today toll free at 877-242-02